This is Dr. David Schein, and welcome to Business Law 101.
Staffing agency misclassifications could be a big problem for employers. This is Dr. David D. Schein for Business Law 101. And it's as if employers didn't have enough to worry about these days. The U.S. Department of Labor Wage Hour Division has dug in and come up with a new one. This is something that could be very costly for you. So say that your company hires hourly labor from a staffing company. You consider them 1099 contract labor, perfectly reasonable. The problem is your company is relying on the staffing agency to handle compliance for these workers and classifying them as their employees. But if the staffing agency also classifies them as 1099 laborers, you may have a potential problem. And guess what? Under the law, the ultimate employer is going to be found to be your company and not the staffing company. This could produce major costs. With the tight labor market, many businesses are relying on contract labor provisions from these different staffing agencies. So that's part of what's ramped up this problem. Standard rule, as I said, is that the employer is ultimately responsible. Now, there's a concept called joint employer, and this has been used by unions to unionize contract labor who's actually on the payroll of a staffing service, but they've argued, well, we can unionize them at the company hiring them. And the NLRB under certain administrations actually bought into that argument. So there's a lot to worry about here, folks, and it is all very significant and a little bit tough to encounter. So some of the things to think about. Here's an example of a recent case that will really get your attention. DOL, Department of Labor, recently sued a healthcare management business for $19 million it claims was owed in back wages and penalties for workers who came through a staffing agency but were classified as 1099 under the staffing agency. Yeah, tough deal, folks. The staffing agency was not even named in the lawsuit. Again, the doctrine under which this was brought is called the joint employer doctrine. Tough situation. As always, caveat emptor, let the buyer beware. Be sure to consult with your attorney regarding your contracts with all situations, not just staffing agencies, but this certainly highlights your contracts with staffing agencies. This is Dr. David D. Schein. Thanks for joining us for this special episode of Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.